My esteemed sister and brother judges, Shri Bhupendra Singh Chodasma, Honorable Cabinet Minister for Law and Justice, Shri Pradeep Singh Jadeja, Honorable Minister of State for Law and Justice, Shri Kamal Trivedi, Learned Advocate General, State of Gujarat, Shri Devang Vyas, Learned Assistant Solicitor General of India, Shri Yatin Oza, Learned President, Gujarat High Court Advocates Association, Learned Senior Advocates, learned members of the bar, members of the registry, ladies and gentlemen. High Court is an institution that stands tall as a guardian of the rights of the people, an institution that is empathetic to the needs of the people, an institution that exists as a strong estate of democracy, an institution that is organic, changing with evolving times. This institution is the truest embodiment of justice, which all of us value the most and treat as the summum bonum of our democracy. And most importantly, it is a beacon of hope for the common man. Today, 1st May 2020, High Court of Gujarat commemorates 60 years of its establishment. I, Vikram Nath, in person as 25th Chief Justice of Gujarat High Court, at the outset, from the bottom of my heart, express my extreme pleasure and privilege to be addressing this learned and august gathering on this momentous occasion. On this memorable day, this great institution commands homage, a reminiscence of its glories, offering tributes of two stalwarts who have adorned the bench, and salutations to the valuable contributions of the doyens at the bar. At the threshold of its Diamond Jubilee, it is a time to pause and analyze the extent to which this institution has lived up to the aspirations of the justice seekers. It is also an occasion which gives us an opportunity to reflect as to whether we are preserving the rich legacy and heritage which we have inherited from the great judges and lawyers alike. We have to ask the question whether we are enhancing the image further or there has been some detrition. If we cannot enhance the image which we have inherited, it is our duty and responsibility to at least ensure that it is maintained and no dent is created in it. We cannot always live on our past glory. The people of this country have great trust and faith on the judiciary. That faith is our strength. It has to be maintained at every cost. Late Justice H.R. Khanna, in one of his Tagore Law lectures in 1985, said that the greatest asset and the strongest weapon in the armory of the judiciary is the confidence it commands and the faith it inspires in the minds of the people. The common man considers the judiciary as the ultimate guardian of his rights and liberties. No institution can take for granted the respect of the community. It has high expectations and constantly demands proof of its utility. Dr. S. Radhakrishnan, our former president, said, I quote, if people lose respect for law and respect for the courts which administer law, it will be a bad day for us. It is essential for the country to respect law, for the government of the country to respect law, and for the courts to maintain the sanctity and purity of legal administration and dispensation of justice. That is absolutely necessary if the rule of law has to be continued in this country as it has to be continued, unquote. Let us always remember the great words of Magna Carta. To none shall we deny justice. To none shall we delay justice. To none shall we sell justice. These quotations we must ask ourselves and find right answers as we commemorate 60 years of the High Court. Does our judicial system satisfy the demand for justice? Does it fulfill the expectations of the people? Does the litigant look upon the courts as the temples of justice where it is administered without fear or favor, oblivious of the personalities of the litigants and without regard to their long purse or high status? Does the common man have an abiding and unshakable faith? It is upon the right answer to these questions that our judicial system would ultimately be judged. To uphold and protect this trust, confidence, and faith should be our motto. And by us, I mean all of us, be it my brother judges, judicial officers, lawyers, anyone and everyone connected to this institution. It is this end towards which each and every one of us should strive for. And anyone, I repeat, anyone who acts or wishes to act in a manner that would displace this faith, trust, and confidence would first have to be met by us, the judiciary, that stands tall as the guardian of justice. For a couple of minutes, may I take a dig at this word justice? The very first promise enshrined in the preamble of the Constitution of India is that we ensure for ourselves that justice, social, political, and economic, is given to all, thus reminding the judiciary of this country of its pivotal role in safeguarding the rights of every individual, right down to the person standing at the end of the line. In this context, let me refer to a quick question which will eventually end up as an illustration. This has reference to the famous book Idea of Justice, authored by none other than Nobel laureate Amartya Sen. Three children, Ram, Kavita, and Shyam, are quarreling over who should get the flute. Kavita claims the flute on the ground that she is the only one out of the three who knows how to play it, and it would be unjust to deny the flute to the only one who can actually play it. Shyam, on the other hand, sets up his case for having the flute on the premise that he is the only one among the three who is so poor that he has no toys of his own. The flute would give him something to play with. While Ram points out that he has been working diligently for many months to make the flute with his own labor, and just when he finished his work, just then he complains these expropriators came along to try to grab the flute away from him. So, who gets the flute? The idea here is to appreciate the aspect that it is not easy to brush aside as foundation, lest any of the claims based respectively on the pursuit of human fulfillment or removal of property or entitlement to enjoy the products of one's own labor. The different resolutions all have serious arguments in them, and we may not be able to identify without some arbitrariness any of the alternative arguments as being the one that most invariably prevail. The avoidance of reasoned justification often comes not from indignant protesters, but from placid guardians of order and justice. Reticence has appealed throughout history to those with a governing role endowed with public authority who are unsure of the grounds for action or unwilling to scrutinize the basis of their policies. The requirements of a theory of justice include bringing reasons into play in the diagnosis of justice and injustice. Over hundreds of years, writers on justice in different parts of the world have attempted to provide the intellectual basis for moving from a general sense of injustice to particular reasoned diagnosis of injustice, and from there to the analysis of ways of advancing justice. Traditions of reasoning about justice and injustice have long and striking histories across the world. Fairness is central to justice. At the root of justice, there is a term called Matsnyay, which means that in periods of chaos, when there is no ruler, the strong devour the weak, just as in periods of drought, big fish eat small fish. This would be an unjust system. A society is just when both the small and the big can thrive together. Whatever we, without the big damaging the small, whatever be the circumstances, the constant development of theories has provided different but respectively important insights into the demands of a just society. The characterization of perfectly just institutions has become the central exercise in the modern theories of justice. It would be apt, in the above context, to quote a very meaningful and loaded statement which looms on my head and is very close and dear to me and my heart all the time when I sit in the first court of Gujarat High Court. I quote, Law is the king of kings. Nothing is mightier than law, by whose aid even the weak can prevail over the strong. Unquote. We had elaborately planned for celebrating this occasion, but rising to the need of the hour, battling with unprecedented challenges, taking measures to lead the battle for survival, it has been unanimously resolved to defer all celebrations to happier and healthier times. The history of Gujarat High Court goes back to the 1st of May 1960, when the new state of Gujarat was born, segregating 17 territories from the bilingual Greater State of Bombay under the Bombay Reorganization Act 1960. The Standing Order 1015, dated 26th April 1960, proclaimed that, I quote, in exercise of the powers conferred by subsection 2 of section 28 of the Bombay Reorganization Act 1960, 11 of 1960, the President hereby directs that the principal seat of the High Court of Gujarat shall, as from the first day of May 1960, be at Ahmedabad, unquote. The Bombay Reorganization Removal of Difficulties Order number 1, dated 27th April 1960, issued in the name of the then President of India, Dr. Rajendra Prasad, stated that the governor of the new state of Gujarat, before entering upon his office on the 1st of May 1960, shall make and subscribe the oath or affirmation as prescribed in Article 159 of the Constitution of India, in the presence of the senior-most judge available of the High Court for the state, the first governor of the state of Gujarat, Shri Mehendi Nawaz Jung, was thus administered the oath of office in the presence of the Chief Justice and other judges of the newly born state of Gujarat. Thus, it was the judiciary which preceded the executive. The newly constructed building of the Children's Hospital of Ahmedabad was modified to be used for the functioning of Gujarat High Court with effect from 1st May 1960. The High Court continued to function from the said building near Akashvani, Navarakpura, Ahmedabad for almost 39 years. In due course, two new complexes were developed to meet the requirements of time. Presently, it is being utilized for the family courts at Ahmedabad after January 99, when the new building of the High Court on the SG Highway started functioning with effect from 16th January 1999. High Court of Gujarat, wide notification dated 26th April 1960 of Ministry of Home Affairs, Government of India, received its institutional strength with Justice S.T. Desai as its first Chief Justice, along with Justice K.T. Desai, Justice J.M. Shalit, Justice N.M. Miabhoy, and Justice V.B. Raju, allotted from the Bombay High Court. Justice S.T. Desai, the first Chief Justice, while addressing the members of the bar, spoke thus, I quote, everybody working in the High Court will have to be prepared to undergo some difficulty. Our aim should be that people must know how we work here. Ours is a democracy, and it means that people have to take interest in our working, unquote. At the foundation of this great institution lies the learning, humane approach, and sterling qualities of these luminaries. The galaxy of honorable judges who subsequently adorned this august office, 145 in number, set benchmarks of excellence, leaving behind legacies of commitment, learning, and vision to serve, and alleviate the miseries of the common man. Late Justice P.N. Bhagwati, who subsequently became the Chief Justice of this court and then the Chief Justice of India on 12th of July 1985, is considered as one of the most brilliant judges of our country. Justice A.M. Ahmedi, also from this court, went on to adorn the highest judicial office as Chief Justice of India on 25th October 1994. As a testimonial to the great men who built the edifice of this institution, we have had 10 judges of this High Court: late Justice J.M. Shalit, late Justice D.A. Desai, late Justice M.P. Thakkar, late Justice S.B. Majmudar, Justice G.T. Nanavati, Justice M.B. Shah, Justice C.K. Thakkar, Justice J.M. Panchal, Justice Anil R. Dave, and Justice M.R. Shah adorn the benches of the Supreme Court. Late Justice P.T. Desai, renowned as the fiercely independent judge, I am told, had declined elevation to the Supreme Court, had the unique distinction of being a Chief Justice of 3 different High Courts. Gujarat High Court parted with as many as 13 judges who went on to become Chief Justices of different High Courts all over the country to carry forward the legacy of this great institution. Late Justice T.U. Mehta, Himachal Pradesh. Late Justice P.T. Desai, Himachal Pradesh, Calcutta, Bombay. Justice A.P. Rawani, Rajasthan. Justice B.C. Patel, Jammu and Kashmir, Delhi. Justice K.R. Vyas, Bombay. Justice M.S. Shah, Calcutta, Bombay. Justice Rekha M. Doshit, Patna. Justice D.H. Waghela, Karnataka, Orissa, Bombay. Justice J.N. Bhatt, Patna. Justice K.S. Javeri, Orissa. Justice Abhilasha Kumari, Manipur. Justice Akhil A. Qureshi, Tripura. And Justice D.N. Patel, Delhi. On this memorable day, we pay homage to the contribution of all the past judges and chief justices who have had the privilege of serving this temple of justice. As noted by late Nani Palkiwala, there can be no excellence in law without there being excellence in lawyers. And lawyers, men of character and learning, have shone bright and long in the legal firmament. As much as the judges, it is the Gujarat Bar that has given the Gujarat High Court its unique culture and reputation. This is a bar that is independent, unforgiving of moral and legal transgressions, and yet strangely a gentle bar that adopts as its own every judge who sits here. The first among them all, Sri J.M. Thakur, prominent original site counsel from Bombay, appointed as the first Advocate General of Gujarat on 3rd May 1960, which office he held with great distinction for 40 years, 1960 to 2000. He was the only Advocate General of the state to have taken a stand before the Supreme Court in favor of the detainees in the case of Additional District Magistrate Jabalpur versus S.S. Shukla, reported in 1976, Volume 2, SCC, page 521. It is recorded in paragraph 376 of the report in the judgment of the then Chief Justice Y.V. Chandrachud. It speaks volumes of his sterling qualities of courage, fairness, and learning to have commanded the confidence of different governments with different ideologies. For the longest tenure ever, he has remained the most revered senior law officer to have nurtured the bar, leaving behind a legacy of the highest state law officer being impartial and independent. Eminent lawyers from this court have risen to the pinnacle of the legal profession. Late Shri Kirit Rawal and Shri Tushar Mehta have graced the second highest rank for the law officer of the central government as Solicitor Generals of India. This great institution stands tall on the shoulders of many who have walked the corridors of this court, some of whom we are happy to have with us today, but are no longer in active practice. Any inadvertent omission may be pardoned, and I take this opportunity to pay homage to their contribution. Late H.M. Choksi, the first government leader of the state. Late C.T. Daru, late H.K. Thakur, late D.K. Shah, late Giriraj Desai, late Magan Bhai Barot, late Haru Bhai Mehta, late I.M. Nanavati, late S.K. Javeri, late Narendra Oza, late Niranjan Mehta, late J.R. Nanavati, late Vitthal Bhai Patel, late Sharad Vakil, late Arun Mehta, late Girish Bhai Patel, late J.P. Shah, Shri Mayur Bhai Pandya, Shri K.J. Shetna, Shri K.G. Wakharia, Shri K.H. Kaji, Shri B.R. Shah, Shri P.M. Rawal, and many more have left an indelible mark on the judicial expositions of the court. The roll of honor is enough to fill a volume. Gujarat High Court has a distinction of conferring 65 senior designations, the first being Shri J.M. Thakur in September 1991. Ms. Vasuben Popatlal Shah was the first lady advocate to be conferred the designation in 1995. The credibility of an institution is reflected in its judgments. Gujarat High Court has always led from the front. Law reports are replete with judgments in all fields and facets of law. The various areas of law where Gujarat High Court stands tall with its judgments cover environmental issues, ban on immersion of idols in rivers, stopping of sand mining in riverbeds, human rights, criticism of marital rape, rights of accused not to be paraded in public, human rights of army men, taxation, embracing technology to the fullest, with decisions on service of summons through email. It has to its credit more than 250 full bench and larger bench judgments, covering almost every field and subject of law. A tribute to the values and traditions this institution has vehemently upheld. Referring to even some of them would be a Herculean task. The High Court of Gujarat has been the pioneer in visualizing and widening public interest jurisdiction to respond to concerns of the common man, transgressing all procedural barriers at a point of time when Asiad and SP Gupta judgments were still to see the light of the day in the Supreme Court. Justice MP Thakkar, as he then was, tweeted a letter written by a widow to the editor of a newspaper, narrating her plight for want of family pension as a writ petition. One common thread that flows through all these decisions, all such initiatives, activities, is the thread of justice and truth. I have the good fortune of following in the footsteps of some of the most illustrious and eminent jurists that India has ever produced. With the support of the entire judicial system of the state of Gujarat, I will make every endeavor to keep this legacy strong and flying high, always and ever. One tradition of Gujarat is revered for across the country is the amicable relation between bar and bench. Jointly engaged in the legal pursuit of justice, together they have overcome the toughest challenges faced. One such challenge was the unprecedented destruction and devastation brought by the earthquake on the 26th of January 2001. Large number of lives lost, cities destroyed. One of the most significant contributions of the Gujarat High Court in its 60 years of existence would be the introduction of the concept of judicial ombudsman by the then Chief Justice D.M. Dharmadhikari, which resulted into solving of 48,000 cases of earthquake victims. Propounded in the case of Bipin Chandra J. Diwan and others was the state of Gujarat and others, reported in AIR 2002, Gujarat 99. The Gujarat High Court has responded and has risen to the occasion every time, either in times of man-made calamity or act of nature, an uncontrolled event or non-anticipated occurrence. Presently, the world is gripped in the pandemic of COVID-19, where unprecedented lockdown of the country has also forced closure of regular functioning of courts. And invention is the mother of necessity. It has also unlocked and ushered a new phase of use of technological advancement in the working of courts through remote hearing by use of video conferencing and email filing. Post-COVID-19 era shall bring many challenges and things are not going to be the same as before. With health and safety taking precedence over rest of the priorities, millions of countrymen can possibly be gripped in the effect of slowed down economy. Fields of law of contract, company law, labor laws, etc. would trigger various unforeseen challenges. With the extreme acceleration in digital economy, legal field shall be required to keep pace with the same. A book by Richard Susskind, one of the most cited authors on the future of legal service, an IT advisor to the Lord Chief Justice of England, titled as Online Courts and the Future of Justice, says that present infrastructure of justice delivery system shall become obsolete with the advancement of technologies. He maintains as to how online courts will displace conventional litigation and how machine learning and virtual reality are likely to dominate court service. This has been his prophecy in pre-COVID-19 period to better serve the litigants through technology and innovative thinking. It is a time to prepare for this reality, which has come to stay in our lives and which is a panacea to the various challenges present day crisis poses before us. I also take this opportunity to inform that in a short period of time, High Court of Gujarat will be embarking upon the so far not treaded path of paperless courts. It is commendable to note that the Gujarat High Court Advocates Association, with 2,300 registered members in times of this crisis, collected rupees 16,45,830 to help and support its members who are in need, including clerks of advocates and other office staff. A committee of 4 members overlooks the disbursement, which is still in process. We must remember that with great power comes great responsibility. The responsibility that we, brothers and sisters, shoulder is the responsibility to uphold the rule of law, to ensure that there is order in the society, to rid the system of anarchy, and to ensure that the whole system runs like a well oiled machinery. Today, the biggest challenge that is being faced by the judiciary pertains to the pendency of cases. Indeed, justice delayed is justice denied. As of date, we are working with 28 judges, excluding me, as against a sanctioned strength of 52. The total pendency of cases in the High Court as on 28th April 2020 is 1,35,052. In the state subordinate judiciary, there is a total sanctioned strength of 1,521 judicial officers, out of which at present 1,185 officers are working. It may also be in context to mention that the pendency before the lower courts of Gujarat is 16 lakhs 1,769. Today, there are increasing pressures on the judiciary, and the real test lies in the bar and the bench. Meeting these challenges, we must clear the accumulated area of cases, adopt new and emerging technologies to improve working conditions, increase efficiency, and streamline the justice delivery process. Through the war room and the district judicial data grid established in the High Court of Gujarat, apart from the CCTV monitoring for efficiency and accountability, in-depth analysis of statistics is undertaken of the pendency and areas, monthly reports of ranking of court establishments in terms of disposal of 10-year-old cases, and weekly reports of 100 oldest cases of the state are sent to each and every judicial officer of the state. Mission mode efforts are underway for targeted expeditious disposal of 30 plus old cases, which are presently about 4789. Over 60 years, the infrastructure in terms of human resource, technology, extension of various wings of the system have swelled many folds. Today, the institution has a sanctioned strength of 1596 staff in the registry. The present strength of staff in the registry is 1524. Use and application of modern technology in the state of Gujarat and its judiciary is one of the best in the country. The campus and building is self-sufficient to cater to the smooth functioning of the institution. The High Court Museum showcases the judicial history of the state, includes a priceless collection of original documents pertaining to the great trial where the father of our nation, Mahatma Gandhi, was charged with offences of sedition, punishable under Section 124, capital A of the Indian Penal Code, for his articles published in Young India. The first Wakalatnama of the first case, filed in the newly established High Court, and with other memorabilia are on display. It was in Gujarat that the first Lok Adalat was conducted on 14th of March 1982 under the aegis of the State Legal Services Authority. In the calendar year 2019, as many as 3,70,000 cases were disposed of. The mediation movement, which commenced in the year 2002 with the establishment of the Ahmedabad Mediation Center, has pervaded to all districts and family courts. It's no longer an alternate dispute mechanism, but an appropriate dispute resolution. Literacy camps, seminars, workshops are routinely held. Before I close, a word of advice to my young friends. The reason you are addressed at the last is because you are the future of the judicial system of India. These are troubled times. These too shall pass, because history repeats itself, and time has seen events that were disproportionately dreadful relatively. Opportunities multiply as they are seized. A quote from the book The Art of War by Sun Tzu: don't miss the opportunities which come your way. The people of this country lay their right to justice and fairness in your hands. Treat them impartially, kindly, and politely, for it is your duty to ensure righteousness at all costs. With much more years passed by my side relative to your side, I suggest do not directly pursue financial gain, but look for the higher purpose that deems you fit. I would also like to express my gratitude to the government of Gujarat for its constant support in smooth functioning and strengthening of infrastructure. I would be failing in my duty if I do not thank the High Court staff, one and all, for arranging this address via video conferencing mode and for their unending and valuable support for the same. Before I close, let me read out the blessings and good wishes received from two prominent well-wishers from Delhi. Message from Honorable Mr. Justice M.R. Shah, Judge Supreme Court of India. I quote, Dear Chief Justice Shri Vikram Nath, today High Court of Gujarat is completing 60 years of its establishment. For any institution, completing 60 years is a great event. Gujarat High Court has a glorious past and bright future. I have seen many stalwarts in the legal field of Gujarat High Court, both on the bench and bar. I congratulate you all on this great event and an important day. I pray to God to shower His blessings on all of us to achieve the ultimate goal, to deliver timely and less expensive justice to the needy and more particularly the poor and downtrodden, for which the courts are there. I am sure under your able leadership and guidance and by collective efforts of bar and bench, we shall achieve the same. All the best to all of you. God may continue to bless us all. Stay safe. Unquote. Message from Shri Tushar Mehta, Solicitor General of India. I quote, Today is a historical day when the erstwhile bilingual state of Bombay was bifurcated and the state of Gujarat was formed. Simultaneously, the High Court at Gujarat also started functioning. Right from the inception, our High Court and its illustrious judges have majestically maintained its glory and tradition of high constitutional values. Resultantly, the nation has continued to treat our High Court as one of the best High Courts of the country. I convey my heartfelt compliments to all honorable judges and all my colleagues at the bar on this occasion. Unquote. I initially intended this address only to commemorate the past 60 years, but now in the midst of the lockdown, I believe address needs to be supplemented with a message of hope. Therefore, I would like to begin by sending strength to those who are the victims of the strange new enemy. I would further like to send gratitude to those caregivers and who are on the front line battling this unseen and unknown enemy. And I would also like to send my sincere good wishes and regards to the families of those who are aiding the fight against this enemy. I sincerely thank all of you for being part of this remarkable event.
My Lords, Honorable the Chief Justice and all the Honorable Judges of the High Court of Gujarat, Honorable Ministers, respected Shri Bhupendra Singh and respected Shri Pradeep Singh, my distinguished colleagues, learned government leader, learned public prosecutor, and learned Assistant Solicitor General of India, esteemed President, Vice President, Secretary, and other office bearers of the Gujarat High Court Advocates Association, my colleagues, learned senior advocates, and all the practicing advocates of the High Court of Gujarat, the Registrar General, members of the registry, and the staff of this Honorable Court. Very good morning to all. Today is not the day of celebration, but is a day to commemorate a solemn event that took place 6 decades ago and to walk down the memory lane through 60 glorious years of our institution. It was on this day in the year 1960 that we got a separate state of Gujarat along with the establishment of our High Court. Historical indeed. Today the whole world, including our nation, is facing an evil of coronavirus. St. Paul had once said, let us not be overcome by evil, but overcome evil with good. Therefore, during such difficult time, a decision taken by my lords to congregate through video conferencing for sharing the nostalgic moments of our great institution is really commendable. While associating with the views expressed by my Lord, Honorable the Chief Justice on this occasion, I, on behalf of the legal fraternity of the state, as well as on my personal behalf, deem it fit to address this august gathering with utmost reverence. Let me begin by reciting an ancient Sanskrit shloka from chapter 3 of Brihad Aranyak Upanishad. I quote, Om Asto Ma Sadgamaya, Tamso Ma Jyotirgamaya, Mrityor Ma Amrutam Gamaya. Unquote. It means, O God, lead me from untruth to truth, from darkness to light, and from death to eternity. It is really heartening to note that today our High Court has been functioning in the quest of achieving the said goals. As we all know, Gujarat was a part of the erstwhile state of Bombay and was also known as the land of the Gurjars, who ruled Gujarat around 8th and 9th centuries CE. Whereas Saurashtra, also known as United State of Kathiawar, was a separate western state within Union of India from 1948 until 1956, with Rajkot as its capital. In the year 1950, the state of Kutch was created within the Union of India. With the reorganization of the states, the union of the state of Saurashtra, state of Kutch, and the Gujarat region became a part of the biggest bilingual state of Bombay. In 1956, the Mahagujarat movement, also popularly known as Mahagujarat Andolan, started with a demand for creation of an independent state of Gujarat for Gujarati-speaking people from the bilingual Bombay state of India. It culminated in the formation of the state of Gujarat as well as Marathi-speaking state of Maharashtra on 1st May 1960, along with the establishment of a High Court of Gujarat under Section 28 of the Bombay Reorganization Act 1960, as was referred to by my lord. With the establishment of the High Court of Gujarat, 7 outstanding judges were appointed on different dates in the year 1960. The first Chief Justice was Justice S.T. Desai, who was a judge of the Bombay High Court, and along with him, 4 judges, Justice K.T. Desai, Justice J.M. Shelat, Justice N.M. Miyabhoy, and Justice V.B. Raju, were appointed on 1st May 1960, who were then followed by Justice P.N. Bhagwati and Justice R.B. Mehta, both appointed on 21st July 1960, and Justice A.R. Bakshi, who was appointed on 30th September 1960. Thereafter, our High Court was adorned by some great judges like Justices B.J. Diwan, J.B. Mehta, D.A. Desai, S.H. Sheth, M.P. Thakkar, and P.D. Desai. A list of such judges of a High Court is unending, who had immensely enhanced the image of the state judiciary. Towering personalities like Sri J.M. Thakur and Sri H.M. Chopsy were the first Advocate General and the government leader representing the state of Gujarat in our High Court. But how can one forget the glittering galaxy of the leading lawyers who are not with us today and were equally instrumental for the growth of this institution? To name a few, Sri Anna Rosa, D.K. Shah, A.H. Mehta, I.M. Nanavati, C.T. Daru, V.B. Patel, S.B. Vakil, J.R. Nanavati, S.K. Javeri, P.M. Rawal, Maganbhai Barot, H.K. Thakur, G.N. Desai, J.P. Shah, H.L. Patel, H.M. Mehta, S.M. Shah, Girish Patel, A.J. Patel, N.J. Mehta, and K.N. Rawal. At the same time, we cannot forget today's great image of our High Court is also because of the contribution of several leading lawyers who are presently with us, like Sri K.G. Vakharia, B.R. Shah, S.S. Sanjanwala, Mayurbhai Pandya, V.P. Shah, K.T. Mehta. This list is ceaseless. It is indeed a matter of great pride that the High Court of Gujarat has been a pioneer in many areas at the institutional level, while brightening the judicial horizon of the country by rendering bold and path-breaking judgments. I take this opportunity to briefly indicate a few of them. Soon after our High Court came into existence, the first and the foremost controversy raised in the year 1960 itself was about the binding effect of the ruling of the Bombay High Court as a predecessor court. The full bench of our High Court, in case of State of Gujarat versus Gordhanji Keshavji Gandhi, held that the Gujarat High Court, having inherited the entire jurisdiction, power and authority in respect of the territories now forming part of the state of Gujarat, can rightly be regarded as a successor of the High Court of Bombay and would be bound by the decisions of the Bombay High Court rendered prior to 1st May 1960. Pertinently, no such proposition was ever laid down in earlier cases involving the evolution of the High Courts of Kerala, Punjab, Andhra Pradesh, Hyderabad, Rajasthan, and Mysore. During the period, particularly from 1965 to 1980, the High Court of Gujarat was considered to be a torchbearer in the matter of interpretation of taxing provisions, when the judgments given by our court were always being looked upon by other high courts and the Honorable Supreme Court with great respect. It was for the first time in the country in the year 1970 that our High Court took up the task of interpreting the concepts of a life interest and annuity while considering the provisions of the Wealth Tax Act 1957 in case of Commissioner of Wealth Tax versus Arundhati Balakrishna. In the year 1971, the Honorable Supreme Court not only confirmed this judgment of our High Court, but also referred to the same in its various subsequent judgments repeated. It was for the first time in the country that in the year 1972, in case of Balashankar Bhadji versus Charity Commissioner, our High Court took a view that all the temples owned by private trusts which are accessible to public religious worship would be public temples, and the private trust cannot claim an exclusive right in such religious places. Later on, this proposition was followed by many high courts in the country before its confirmation by the Honorable Supreme Court in the year 1994. As was referred to by my Lord, during the course of emergency declared in 1975, a number of High Court judges were transferred, and one of them was Justice S.S. Sheth of our High Court, who was transferred to Andhra Pradesh High Court without obtaining his consent. His transfer order was challenged through his lawyer, a doyen of the legal fraternity of this country, Shri H.M. Sirvai. Ultimately, a full bench of our High Court in case of Sakal Chand Himmatlal Sheth versus Union of India declared the said transfer order as illegal and invalid, while putting great stress on the independence of judiciary as the basic feature of the Constitution. Thereafter, the Constitution Bench of the Honorable Supreme Court confirmed the said judgment. Pertinently, this case became the main platform for the development of the collegium system of appointment of judges in the later years. Once again, the reference was made by my Lord about the public interest litigation, which traces its existence in the year 1979, when Justice M.P. Thakkar passed an order in case of B.K. Martiyani versus Regional Provident Fund Commissioner, taking cognizance of the grievance raised by a widow in a letter to the editor of the Times of India in exercise of the public interest jurisdiction. Ultimately, she was awarded the accumulated amount of Provident Fund contribution to the credit of a deceased husband lying with the office of the Regional Provident Fund Commissioner. Another leading judgment rendered in the year 1981 by our High Court, taking a broad view of locus standi, is in the case of Consumer Education and Research Center versus State of Gujarat, when our High Court granted locus standi to a private trust devoted to the cause of consumer protection, when it challenged the order of the state government to wind up Machu Dam Inquiry Commission set up under the provisions of Commission of Inquiry Act 1952 to investigate the collapse of the dam, resulting in serious disaster so far as the community was concerned. Pertinently, both these cases were decided prior in point of time as compared to subsequent judgment rendered by the Honorable Supreme Court in case of S.P. Gupta versus Union of India, laying down for the first time a law relating to locus standi and public interest litigation. In the year 1982, the concept of holding Lok Adalat came to be evolved for the first time in the country by our High Court, when the first Lok Adalat was held at Una in Junagadh district. It was thereafter that other high courts in the country started experimenting with the same concept, whereas in the state of Gujarat, a larger number of cases relating to motor vehicle accident claims, matrimonial and family disputes, industrial disputes, land acquisition and compensation disputes have been successfully dealt with by the conduct of Lok Adalats in succession. In the year 1995, in case of Rasiklal Acharya versus State of Gujarat, our High Court reiterated the mandate of 73rd and 74th Constitution Amendments, conferring a constitutional status upon the institutions of local self-government at the grassroots level by declaring the Gujarat Local Authorities Temporary Postponement of Election Act 1994 as ultra-virus, with a lightening direction to the state authorities to get all the needful done within only 1 month to conduct and finish election of all the local authorities in the state. The devastating earthquake of 26 January 2001 had shaken the whole of our state, leaving thousands of people dead, injured and homeless. The entire nation and the world had shown exemplary compassion and cooperation by extending all possible help. During such difficult time, the former Chief Justice V.J. Diwan, along with prominent citizens, had brought a writ petition for ensuring speedy and effective remedy to quake victims. It was in the said public interest litigation that the learned division bench of a high court, consisting of former Chief Justice D.M. Dharmadhikari and Justice P.B. Majumdar, gave a landmark judgment evolving an institution of ombudsman in each of the districts to provide a means of redress to victims and the mechanism for successful functioning of the said institution. We must note this was the first judgment of its kind in the entire country. Interestingly, in the year 2013, we witnessed a very bold decision of our High Court in a public interest litigation initiated in case of Rajendra and Shah versus Union of India. In the said case, Part 9B, added to the Constitution by way of 97th Constitution Amendment Act 2011, recognizing the right of the people to form a cooperative society as a fundamental right, came to be declared unconstitutional. The whole Chapter 9B came to be cautioned set aside. This was so held because of non-compliance of Article 368(2) of the Constitution, which mandates the ratification by the state legislatures of not less than one half of the states if the Constitution amendment is with reference to the state subject, which was cooperatives in the said case. It is the irony of the situation that, as against the sanctioned strength of 52 judges, our High Court is presently functioning with only 29 judges. However, the fact remains that the growth of our High Court has been phenomenal while dealing with a very rich litigation, ranging from taxation laws to commercial laws, intellectual property laws to admiralty law, and the constitutional law to civil and criminal laws. Our High Court has been a pioneer in the field of providing e-delivery justice at all levels to all the stakeholders. Pertinently, regular case information related services are rendered through website of the High Court, wherein advocates get the specially developed user-friendly e-book type cause list of the next day directly sent to their email. SMS is also sent informing the listing of the matters. The advocates can now file leave notes and sick notes online. The order and judgments passed in a matter are automatically sent to through email. In view of today's unfortunate situation of lockdown, our High Court has successfully and remarkably implemented the use of video conferencing for hearing of urgent matters and e-filing of such matters without anyone having to come to the High Court premises. A splendid success. We all should indeed be proud to say that our High Court's contribution to India's judicial system is a long and luminous one. These instances are merely a bird's eye view of the glorious judicial past of our esteemed High Court at the institutional level. Before I proceed further, I must recall 4 great milestones witnessed by our High Court at the individual level. The first one is of our former Advocate General Sri J.M. Thakur, whose most successful and unstinted tenure of 40 years as the Advocate General of the state of Gujarat is a matter of record in the entire country. He had the rare distinction in appearing and supporting the case of detainees before the Honorable Supreme Court in a famous case of ADM Jabalpur, wherein the case of detainees was turned down while a majority judgment rendered in the year 1976, which has now been overruled in the year 2017 in case of K.S. Puttuswamy. He had also the privilege of appearing and opposing a suo motu review application filed in a well-known Keshwanand Bharti case. The second milestone is about having as many as 21 judges being part of our institution at one or the other point of time who have been so far elevated to the Honorable Supreme Court, including 4 judges, Justices P.N. Bhagwati, A.M. Ahmadi, B.N. Kripal, and K.G. Balakrishnan, as having reached the highest judicial office of the Chief Justice of India. The third milestone at the individual level is that of Justice P.D. Desai, former acting Chief Justice of our High Court and former Chief Justice of Himachal Pradesh, Calcutta and Bombay High Courts, who was offered judgeship in the Supreme Court on 6 different occasions, though respectfully declined every time owing to the personal reasons. And the fourth milestone is about 2 senior advocates of our High Court, Sri K.N. Raval and Sri T.R. Mehta, having acquired the distinction of being the Solicitor General of India. As we all know, after establishment of our High Court, it started sitting in an old building meant for Children's Hospital near Nabarangpura, Ahmedabad. Though the state building had a lot of limitations, as far as working of the High Court was concerned, it was functional and cohesive. A small bar room and even a smaller tea room were actually serving as a meeting points for the bar members, more particularly around 12:30 p.m. for having a cup of tea and a coffee along with refreshments. Every Friday, lawyers were looking forward to having a handful of peanuts, gram and pieces of ginger. Whoever practiced in the old building, I'm sure, would vouchsafe that each bar member was fairly aware about the well-being of the others, despite there being no close acquaintance. Though majority of the courtrooms were small, lawyers felt extremely comfortable while arguing their briefs. The furniture and fixtures were conventional and antique in design and decor. Besides, the building was centrally located and thus convenient to all. It was owing to this reason that when the state government considered having a new building for the High Court on a larger parcel of land on the outskirts of the city of Ahmedabad on now present Circuit Gandhinagar Highway, the fraternity of lawyers was not agreeable to the idea. Finally, our High Court shifted to the new building on 16 January 1999 after witnessing a grand inaugural function attended by judges of the Supreme Court, former Chief Justices A.S. Anand, S.P. Barucha, and B.N. Kripal, along with the judicial and legal fraternity of the state. Today is the day to pay tribute and homage to all those who have been associated with our High Court, including our most efficient staff of the registry, who work selflessly and without any fanfare. Today is also the day to cherish the past and look forward to the future. In this endeavor, there is always a need for unity between the bar and the bench, which are like two wheels of a chariot that dispenses justice. The Bar Council of Gujarat and Gujarat High Court Bar Association, led by persons like Senior Advocate Sri K.J. Shetna, an authority in criminal law, have always worked shoulder to shoulder with the state judiciary, and in the state process, there has always been a relentless support by the state executive. In this connection, closing mantra of Ashtagna practice from Rig Veda is very apt. I quote, Swasti Prajapyaha Pariparyantam Nyayana Margena Mahim Mahishaha Go Brahmana Yaveha Shuravastu Dityam Lokaha Sabastaha Sukhino Bhavantu. Unquote. It means, may prosperity be glorified, may well-being of the people be protected by law and justice, may divinity and erudition be protected, may all the persons become happy and free. Let us all pray to the Almighty that we may overcome this war against coronavirus valiantly. While concluding, I may draw inspiration from the words of my Lord Honorable the Chief Justice Mr. Vikram Nath, used in his opening article titled Writing History, Creating History, in the commemoration book called Gavel and Pen, published while celebrating the completion of 150 years of the establishment of High Court of Allahabad. I must say it's very apt. I quote, let us all move forward in unity to face the challenges of the future with a bar rising by knowledge and bench bowing to wisdom, knowing fully well that the best of Allahabad High Court is not the past, unquote. So, we all look forward to even better future of this august institution, which has proven to be one of the leading high courts in the country. This reminds me of the words of the world's first legal philosopher, Marcus Tullius Cicero, and one of the greatest orators in 106 BC, who had once said, justice is the crowning glory of the virtue. Today, we all wish, pray and hope that the same virtue of justice always remains embedded in our High Court of Gujarat for all times to come, which has given us great lawyers, great judges, and above all, great human beings. Thank you all. Jai Hind and Jai Jai Garvi Gujarat.
My Lord the Chief Justice, his other honorable companion judges of the High Court of Gujarat, Honorable Minister for Law and Justice, Shri Bhupendra Singh Chudasma, Honorable Minister of State, Shri Pradeep Singh Jadeja, former judges of the Supreme Court of India and former judges of this court, learned Advocate General, learned government leader, learned public prosecutor, learned Assistant Solicitor General of India, learned senior advocates, my esteemed colleagues at the bar, and officers and members of the registry. We are witnessing a historic day as this august institution completes 60 years. We are assembled today to commemorate 6 decades of glory, intellect, ethics, and morals that this institution is equipped and blessed with. Though I joined the bar in 1982, after the High Court had completed a little over 22 years, I stand advantaged hailing from a family of lawyers and also have the advantage of being fully acquainted about the functioning of the High Court, owing to a lot of seniors who enlightened me on account of their standing at the bar for a very inception itself. Fortunately, today amongst us, there are 6 luminaries who have witnessed the functioning of this High Court right from day one. First being Honorable Justice G.T. Nanavati, who started his practice shifting from Bombay to Gujarat on 1/5/1960. 5 learned senior advocates, namely Shri K.H. Kazi, Shri D.D. Vyas, and Shri S.H. Sanjanwala, are also with us on this live streaming by way of video conferencing. Other 2 advocates who also started their practice in 1960, 1st of May, are Shri B.R. Shah and Vasuben Shah. We are fortunate to have all the 6 of them with us today. As Advocate General rightly pointed out, that when this institution came into existence on 1st of May 1960, it started its functioning in a building owned by AMC, which was originally earmarked as a children's hospital, and we continued to function as such till 16th of January 1999. The area where the High Court functioned was popularly known as Income Tax and Akashvani. And when it began its functioning, it was not in the heart of the city, but soon became a part and heart of the city. The memories of that building, Learned Advocate General has in extenso, leaving hardly anything for me to say, is still cherished by all my friends who practiced in the premises. Though full of inconvenience, with little parking facility, the togetherness of the members of the bar was unmatched. The court commenced functioning on 1st of May with a strength of 5 honorable judges, namely Honorable Justice S.T. Desai as the Chief Justice, who after his retirement started his practice at Delhi in the Supreme Court and was known as Jumping Desai, inasmuch as for 30 long years he practiced in the Supreme Court and was seen as a youngster moving in the lobby of the Supreme Court. Justice K.T. Desai, Justice J.M. Shalat, who became the first judge from this court to add on to the bench of the Supreme Court, Justice Miabhai, and Justice Raju, who was the last judge to be elevated to the High Court from a non-legal background, namely ICS. At the time of bifurcation, great legal luminaries switched their practice from Bombay High Court to Gujarat, and first to be named is great Mr. J.M. Thakur, the first Advocate General who stayed as the same for a record period of 40 years and 6 months, except for some time when he had to stay in Delhi, which was then Mr. K.H. Kazi had taken over the reins of office. Governments after governments changed, and upon such change, as Shri Thakur would tender his resignation, the same would stand rejected, and he was requested to continue. And that went on for 4 decades. Such was the greatness of the man who not only held the post of Advocate General for 40 years and 6 months, but was the longest serving president ex officio of the Bar Association from 60 to 83 and chairman of Bar Council of India for a period of over 2.5 decades. 1960 saw many more luminaries who had extensive practice and immense repute as counsels in Bombay High Court, who chose to switch over to this court, like Shri Edi Desai, Shri S.H. Sheth, Shri N.R. Rosa, Shri K.H. Kazi, Shri Arun Mehta, Shri V.P. Patel, Shri S.B. Vakil, Shri Karlekar, Shri Chhatrapati, Shri M.R. Bharot, Shri Himmatlal Choksi, Shri C.K. Shah, Shri N.C. Shah, M.C. Shah, and many more. The stalwarts that you hear of today, either as lawyers or judges, commenced practice in this court on 1st of May 1960 as budding aspirants junior, such as Justice P.D. Desai, Justice G.T. Nanavati, Justice Shri B.R. Shah, Shri B.J. Shalath, Shri J.N. Shah, and Miss Vasubhen Shah, who was the only lady advocate, along with Manorama Ben, that time, who started the practice on 1/5/60 and came to be designated as the first lady advocate of the Gujarat High Court. They are all stalwarts today, either in the bar or on the bench. Right from the first day of 1960, High Court has been school of intellectuals formed by a culmination of legal luminaries coming from Bombay, Ahmedabad, and Saurashtra. Seniors practicing in Ahmedabad were legends like I.M. Nanavati, whom I consider to be my role model, Shri C.T. Daru, Shri Giriraj Desai, whom I consider to be my ideal in the profession and who held the post of government leader for 12 years, Shri Sanjanwala, Shri Jhaveri. On the criminal side, we saw legends like D.K. Shah, H.K. Thakur, and many more. Iconic names that were added to Gujarat High Court from Saurashtra were like Justice M.P. Thakkar, who became Chief Justice of Gujarat High Court and thereafter a judge of the Supreme Court, Shri A.R. Bakshi, who was the Advocate General of Saurashtra and who came to be elevated as a judge of this court again in 1960, Shri D.D. Vyas, Shri S.M. Shah, Shri J.R. Nanavati, and Shri P.V. Hathi. This culmination gave birth to an ideal institution that came into being as an epitome of morals, intellect, and professional ethics. Each of them has contributed in immeasurable terms in different fields of law to the institution, but due to paucity of time, I find it difficult to account for their contributions individually. Then 1961 saw two stalwarts joining the bar, namely Shri S.B. Majmudar, who resigned as an officer of the State Bank of India and joined the bar, and great Shri P.M. Rawal, who shifted his practice from Surendranagar to Ahmedabad. 1962 saw the induction of 4 young juniors who are considered doyens of the bar: Shri K.G. Vakharia from Rajkot, Shri K.S. Nanavati, Shri K.J. Shetna, shifted from Surat, and Shri Harubhai Mehta, a practicing advocate in Rajkot, who came to argue as a party in person, challenging order of his own detention, and the then CJ was so impressed with his arguments that he requested him to move the base to this court. 1963 saw another legal luminary, Shri S.N. Shelath, who resigned as an officer of Bank of India, to join the profession. Thereafter, in the era of 60s, we saw a number of doyens at the bar and great judges joining the bar. To name the few: Shri Haribhai Shah, Mrs. Ketiben Mehta, Shri Niranjan Mehta, Shri C.K. Thakkar, Shri S.D. Shah. Either of them were made themselves to be a great lawyer or an outstanding judges. Era of 70. So again, some very good addition to the bar in form of Shri J.M. Panchal, Shri M.R. Anand, Shri Sudhir Nanavati, Shri P.M. Thakkar, Shri P.B. Mazmudar, Shri Nirupam Nanavati, Mr. Kirit Rawal, Shri Mohit Shah, Shri S.V. Raju, Shri Mihir Thakur, Shri Dushyant Dave, Shri Saurabh Sopakar, and our esteemed Advocate General, Kamal Trivedi, all my seniors and thorough perfectionists. I should add that most of these luminaries have excelled in the profession without any legal background or backing whatsoever. The institution has carved a niche for itself right from the day, one with equal contribution from the bench and the bar. Like the bar which I mentioned previously, the bench has also been enriched with several luminaries, to start with great Justice Bhagwati, Justice Diwan, Justice J.B. Mehta, Justice J.M. Sheth, Justice A.D. Desai, Justice D.A. Desai, Justice S.H. Sheth, Justice M.P. Thakkar, Justice T.U. Mehta, Justice D.P. Desai, Justice A. Dave, Justice P.D. Desai, Justice B.K. Mehta, Justice Ahmadi, Justice Mazmudar, Justice G.T. Nanavati, Justice M.B. Shah, Justice C.K. Thakkar, Justice J.M. Panchal, Justice Anil Dave, Justice Mohit Shah, and many, many more. The court has also witnessed great chief justices coming from outside the state of Gujarat, like Justice Poti, who was the first judge to come from outside the state upon implementation of the policy to have the CJ from outside the state. Though, of course, the first CJ to come to Gujarat from the other state was Justice Obul Reddy from Andhra Pradesh. But that was considered to be a punishment transfer and not a transfer by way of a transfer policy. To name few others, Justice Gokul Krishnan, second longest served Chief Justice of Gujarat High Court, Justice Ray, Justice Kripal, Justice Balakrishnan, Justice Dharmadhikari, Justice Bhavani Singh, Justice Radhakrishnan, Justice Mukhopadhyay, Justice Bhaskar Bhattacharya, Justice Subhash Reddy, and of course, my Lord the Chief Justice, whose dynamism will take this institution to even the greater heights. In the initial year, as Learned Advocate General said that how the law developed, this court was wedded to traditional litigation under civil law like specific relief, contract, partnership, partition, easement, land disputes, Bombay Rent Act, laws relating to agrarian reforms, and typical offenses prescribed under the Indian Penal Code. It was in its infant stage, but within a period of a year or two, this court took giant leaps. It developed and mastered such litigation, which was considered to be prerogative of only veteran high courts like Bombay and Kolkata. The High Court worked as one. The bar and the bench, hand in hand, led the High Court to newer avenues like writ litigation. And in the first year itself, writ work started as if this court had been dealing with the same since eons. It was so effortless. The same was with the other laws like Company Law, Industrial Disputes Act, Bombay Industrial Relations Act, taxation laws, which did not exist in 1960, but this litigation in and after 1961 came to be par with all previous litigation. In 1967, the first Gujarat Lawyers Conference took place at Town Hall in the city of Ahmedabad. And in the said conference, Honorable the Chief Justice of India, Sri Subba Rao, had said that this was the most infant yet most effective, people-oriented, and one of the best high courts of the country. I will try and get the copy of the dignitaries who addressed the audience on that day. Not only the laws and the litigations developed, the standard of the bar and bench developed and stayed so high that the mark still remains as a reminiscence for the people who have been witness of that era. As we commemorate the 60th year, I would like to share a few anecdotes, instances which will benefit the junior members of the bar and will also act as guiding light to honorable judges. Judges of that era had a humanity reflecting in each and every judgment of theirs. By this, I don't mean to say or discredit that it doesn't in the present day. But since I am referring to that age, it is from that day till today, the High Court of Gujarat is wedded to welfare of the people, to protect the rights of the people, and to come down heavily against any unconstitutional, illegal, or immoral act at the hands of either the private persons or the government. The iconic judges, but they held keen interest in development of the bar members. The judges not only groomed, but also on keen lookout for deserving candidates for judiciary from amongst the advocates. Look at Justice Bhagwati. When in the morning Justice B.K. Mehta must have woke up, he would never in his wildest dream thought of that he would be invited to become a High Court judge on the same evening. he was here to assist Mr. G.N. Desai in a first appeal, which was to be heard by Justice Bhagwati and Justice Sarela, if I am not mistaken, the division bench consisting of. Mr. Desai was occupied and was on his legs before the other court, and Justice Bhagwati asked B.K. Mehta to open the matter. That was the first matter of Justice B.K. Mehta before this court. And when the arguments were over, same evening Justice Bhagwati called him and offered him High Court judgeship. And look at the contribution of the judge. There is hardly any field of law, any subject under any field of law that Justice B.K. Mehta did not dealt with it sufficiently, and his judgments are still a guiding factor to all of us. Justice B.J. Diwan, the longest serving Chief Justice, was very clear that rather than having judges with bright and brilliant academic career with zero touch to the ground level, I would prefer advocates as judges who have worked and are aware about the ground reality of the people and miseries of the people. Justice D.A. Desai had never dealt with Industrial Dispute Act or company law when he was practicing. But look at his judgments on those laws. All the judges of that time were nothing short of encyclopedic knowledge on the subject. These judges became stalwarts because they were of their robust sense, acumen, and intensive research and study. I refer to these three judges in particular because either they retired or they were elevated to Supreme Court before I joined the bar. After I joined the bar, the judges before whom I appeared, whom I have seen as advocates, thereafter as judges, I will come to it little later. I am changing my speech than what I had originally prepared, in as much as, and I am now going extempore, because as much as what I had written, the speech of my Lord the Chief Justice and more so of Learned Advocate General leaves nothing from what I have written to be read. Those were the days where today's juniors must learn how the seniors were working. I have not missed a single opportunity to give one illustration of Justice Mazmudar as a young lawyer, Senior Justice Mazmudar, as a young lawyer. It was a Saturday when he was leaving the office, and his senior told him that this matter limitation expires on Monday, and please see that matter is ready and draft it out today or tomorrow. At 4 o'clock, when Justice Mazmudar's family came, the senior inquired why the family is here. So he said that, sir, I had to prepare this matter and we were to go for a movie. And that movie, since this matter was to be prepared, I have given up. So senior naturally asked him that it was Monday, you could have done it on Monday. He didn't reply then, but later on he said, when I was given an option today or tomorrow, I have to take it today. A great lesson for a juniors who are either viewing this on YouTube or are going to see hereinafter to follow. Time is less. There are a number of such illustrations. But as my Lord the Chief Justice and Learned Advocate General said, that this is the institution which has always, without fear or favor, bias or ill will, truly to its oath, discharges duty in protecting the democracy and fundamental rights, even during the darkest day of emergency. When I joined the profession, a great judge, a personality of a lion in him, was the Chief Justice, Justice M.P. Thakkar. He is the one judge whom I have seen grooming the juniors. He is the one judge whom I have seen taking keen interest in developing the bar. He is the one judge whom I have seen delivering his judgment with utmost human touch and absolutely would stand to the courage of conviction. A senior advocate now and a very junior in those days, 1982, was arguing a matter before my lords. He was not able to express. He was finding it difficult. And I still recollect MP Thakkar sir saying that forget that you are in a court. You can argue as if you are arguing before your father. Still, the learned advocate was not comfortable and got rather conscious. Justice MP Thakkar said that we can't permit you to argue in Gujarati in this court, but if you can come to the chamber and argue in Gujarati after 5 p.m. It was not as if Justice Thakkar was not able to get the crux of the matter, but he wanted the junior to open up, which worked wonders in uplifting the advocate's morale and boosted his confidence extensively. It is the very judge in 1975 who delivered a judgment when second proviso to Article 311(2)(b) was invoked and several railway employees were dismissed. Summary. Everybody knew that orders were under direct instructions of the then Prime Minister. Yet Justice Thakkar stood the test of the time and said that order is dumb, deaf and blind, and set aside all the orders, giving reasons as to why they were dumb, why they were blind, why they were deaf. One of the most illustrious judge whom everybody in this court respects at the bench or at the bar, and much about him having been said by learned Advocate General, is our Justice P.D. Desai. Look at the greatness of a judge. Whenever sitting on the dais and a junior advocate arguing a matter, he found any lacuna in drafting of the petition by a junior advocate, he used to dictate the amendment from the dais and would ask the advocate to come after recess with the amendment. Then would allow the draft amendment and pass appropriate orders. One of the most junior friendly judges who only showed such leniency to honest mistakes and lapses. His contribution is unmatched, and I will urge all my junior friends to kindly read his exemplary judgment, which shows his intolerance for any unjustified, illegal and unconstitutional action. When we go to the days when I was a beginner, there are a number of instances, actual instances and in general. But one I would like to share is when Justice M.R. Shah, then a practicing lawyer, mentioned a matter at 2 p.m. before Justice R.C. Makad. Mind you, that was a day when Justice Makad's son was getting married, and he was available only up to 2. When a matter was mentioned, Justice Makad initially declined, saying that he has to go for his son's wedding. The learned advocate may approach the Honorable Chief Justice, and the other bench would be allotted this matter. A request was made that, sir, that will consume time and my matter won't be heard before 4 p.m., before the huts would be demolished. Court master was immediately asked to send the papers, and learned advocate asked to wait for 15 minutes. At 2:20 p.m., the orders were passed. Those were the days when recess used to be at 2 p.m. Orders were passed, and then Justice Makad left. These are some instances which I thought there are a number of many, but I can't share it for paucity of time. Again, coming to the institutional glory, In this development of the institution, the role of seniors in investing the considerable amount of time to shape and groom their junior colleagues and other junior colleagues not attached to their office also cannot be forgotten. Seniors would work tirelessly both towards matters and towards uplifting the morals and acumen of their own and other juniors. There have been so many instances where seniors would sit next to the juniors in the court and junior would be encouraged to argue. In 1988, a matter came up before the court where two different political parties were governing the Ahmedabad Municipal Corporation and the state of Gujarat. The municipal commissioner, according to the elected wing, was not permitting the elected wing to function. And there is a provision in BPMC Act that if by a 5/8 of majority resolution is passed by the corporation, then the municipal commissioner has to be recalled, and the state was not doing so. Therefore, AMC filed a petition and several PILs were also filed. Shri PM Rawal and Shri HL Patel were leading the petitioner's side, and I was as a raw junior assisting them. Mr. Rawal began testing my preparedness 2 days prior to the date of hearing, and just when the matter was called out, he informed the court that I will sit beside Mr. Oza and he will argue the matter. There are many such incidents which I have witnessed and heard of. At the same time, expectation of assistance were extremely high. Even the minutest lapse on the part of assisting junior would invite the wrath of his senior in the open court, which wrath many of us faced at the hands of two doyens of the bar, namely Sri G.N. Desai and Sri S.B. Vakil, who were perfectionists and hard taskmasters of those times. The offices and chambers of luminaries like J.M. Thakur, I.M. Nanavati, C.T. Daru, Sri N.R. Oza, Sri S.B. Vakil, and Sri J.R. Nanavati have given us professionals who are recognized today as doyens either at the bar or judges of an outstanding caliber. Though the bar had and has members who subscribe to different ideologies, they have always stood one when the question came of independence of judiciary. To start with, in 1975, elaborately learned Advocate General mentioned about how a petition was filed before the High Court by late Justice Ashet Sheth challenging this order of transfer. Practically one and all, advocates signed the Wakalat. They stood as one unit to fight for independence of judiciary. In 1983, when deliberately, purposefully Justice P.D. Desai was sought to be victimized, under the leadership of Sri J.C. Patel, the first president of the bar agitated for 36 days, and ultimately that yielded the result, and Justice P.D. Desai was appointed as Chief Justice of Himachal Pradesh High Court. In 1987, again, on non-elevation of Justice N.B. Patel, bar fought tooth and nail for independence of judiciary, and lastly, similar unison was shown when the question of transfer and elevation of Justice Qureshi came into controversy. Many things to be said, but I have consumed a lot of time. At the end, I would only say that we all, more responsibility on lawyers, and judges have to act and work as perfect fitted wheels of the two sides of chariot, so that our institution achieves a great height and a glory. At the end, I would only say that this august institution has always been protector of fundamental rights and always kept its flag flying high. And I feel honored and privileged to be here to speak for and on behalf of my association, which has served as a very important organ of this institution. Thank you so much.
पूरी गैलरी में है ना? ठीक, बस एंड मीटिंग